Tuesday, blood, it will.
8 weeks on our NMT.
Milord, I appear in 47.3 and 4, Milord, that is Tiak Ahmad. Milord,
We are not in that.
since the order is relied upon same order, Milord,
Who is
that,
same order?
Milord,
Sorry?
Same order.
one,
Notice is
two,
issued?
yes, Milord may issue notice in that also. They are also fresh matter.
All
Milord,
27
I was
matters,
only saying,
all
saying that this quash order, they are relying in PMLA proceeding now, because the ED also filed complaint.
just show this
Notice
order
has been
of this
issued.
court that
You want to argue with this?
notice has been issued.
Lies, my lord. Lies, my lord. Lies.
No,
After 8 weeks.
I am pointing out, Milord, because I know.
We
as
are
a
not
matter-
granting any interim order right now.
Yes.
Of life.
48, there is a letter, adjourned as per letter.
Yeah, Your Lordship, the order we were directed to file is currently under translation.
Very well. We have adjourned as per your prayer. 3
Okay.
weeks.
Grateful.
But 49, in terms of your lordship's last order, we have filed, my lords, a thin paper book containing the relevant records of the trial court. Now, this person, my lords, this is a legal
What is
service.
the nature of your physical disability?
Lords, it's about 50%.
50%, you are disabled to do what? We couldn't understand from the certificate.
Yes, my lord.
It's all scientific terms, medical terms.
It is, my lord, that the right side of the body is about, my lords, he suffered a paralysis because of the accident that he suffered, a road accident that he suffered. So the right side of the body, my lord, that is what I have understood from the medical terms on doing after Google search, that the right side of the body is suffering from a paralysis sort of an attack. So right side of the body is not as strong as the left hand side. So that is the physical disability. Otherwise, my lords, I pointed out before my lords on the last.
When did you suffer this accident and this physical disability?
Yes, my lord, that as per the certificate.
Certificate is 11,
Yes,
certificate is 2011.
2011, and it says, my lords, that this is a case of head injury to the whole body, but it doesn't give the exact date of the accident per se. So this has happened, my lords. It's of the government hospital, Hindura Hospital. And what I had, my lords, very respectfully pointed out to my lords is that he has now undergone almost about 11.5 years.
Right.
And two circumstances, my lords, were held against him because this is based on circumstantial evidence. One was motive, my lords, and the other was that last seen theory. Now, motive, my lords, with great respect, the Honorable High Court rightly rejects because motive flows from his confessional statement in police custody. So that part of the circumstance is gone. The High Court says in paragraph 20 of the impugned judgment. What we are therefore left with, my lords, is only the last seen and nothing else. And therefore, my lords, what I had tried to point out on that day, when we were, my lords, in the absence of the trial court record, is that if your lordship would come to the thin volume, which I have placed on record, and please come to page 1 and 2, its typed copy would be at page 3. And my lord will find what is the initial recording of fact, my lord, by the police. Page 1 and 2, my lords, is the wireless message. Now 3, please turn to page 3. It's in Hindi, but my lord, written in English, so I'll just read page 3. Second line, my lord, it says injured lady. Your lordship has it. Page 3 of the typed copy.
Type copy.
Second line, my lord, injured lady, just after
Okay.
22638.
Injured lady.
इंजर्ड लेडी को अरुणा आसफ अली में लेकर गए थे जिन्होंने एडमिट नहीं किया, फिर ट्रॉमा सेंटर में लेकर आए हैं जिन्होंने भी लोकनायक के लिए रेफर किया, लेकर जा रहे हैं, लेडी होश में है। देन से गीता वाइफ ऑफ सोवेंसो इंजर्ड को ट्रॉमा सेंटर में ही एडमिट कर लिया है, जो कि अपनी चारपाई पर सो रही थी, स्टैंडिंग फैन लगा रखा था जिसके आगे से जाली नहीं थी, फैन लेडी पे गिर गया जिससे लेडी इंजर्ड हुई है। नाउ my lord, this line of recording, which is the first part by the police itself, either, my lord, she was,
What does the postmortem report say about cause of death?
no, cause of death is, my lord, due to the injuries that she has suffered
Right,
all
right.
around.
Now, the case against you is that you had
A gandasa,
with sharp weapon.
yes, gandasa is the,
Gandasa.
yes, gandasa.
Now, gandasa injury and a hand falling on the lady would not be the same.
My lord, the gandasa injuries,
If a fan falls,
I'll tell you, lordship,
so you would be having injuries all over your body.
no, all over the face, my lord, because,
Face or body.
so yes, it is.
So wherever the fan falls,
So, my lord, she has injuries over her face.
where is
Yes.
the postmortem?
Postmortem, your lordship may kindly have, we have filed it on records at page 27 in the same volume.
27.
It begins at 25. And rather it begins, my lords, at page 23. And the injuries your lordship would find at page 26 onwards. So whereas, my lords, initially there were 5 injuries in the MLC, the post-mortem, my lord, page 26, you will have, lordships will have Roman 9, external examination.
Come to 33 and we'll compare it with the.
So 33 is not the number of
To
injuries.
33,
Yes, 33
right?
is the injuries which are there on
The
the face.
chop wound, how can there be a,
No,
huh? This is a chop wound.
my lord, chop wound is the
It
because
cannot
of
be
incident.
because of- No, don't say that.
My lord, with great respect, I am, my lord, not on the post-mortem. I am only respectfully submitting.
No, you showed us.
Yes,
this.
I am showing that, my lord, as
You
the,
showed us that at the initial stage, it was said that fan had fallen.
so my lord, that is one part of it.
Correspond with.
I follow that. Now, that is one part of it. What I am respectfully submitting is that if you discard motive out of the circumstance against me, then the only other circumstance which has been relied upon me both by the learned trial court, so also by the High Court, is only the last seen theory. Now, my lords, your lordships have held consistently that when you are dealing with a case of circumstantial evidence, last seen theory by itself is not a circumstance to ensure conviction. It has to have certain other corroborative materials also. So that law, my lords, we have got, my lords, cited in fact the judgments, and my lords, we have given a list of books.
You were not residing together?
So we were residing together, my lords. My
You are
mother.
residing together, 106 will apply to you?
Yes, so my lord, I'll come to 106 also.
What explanation?
Now, my lord,
did you
100.
offer?
Yes. Now, my lord,
How did your wife die?
no. So, my lord, the point is this. Your lordship has also held that so far as 106 is concerned, it's an exception to 101 of the Evidence Act. And 106 comes into picture if the prosecution, my lords, has placed the foundational facts for conviction, or at least, my lord, foundational facts in the terms of circumstance. So now that is why I started by saying there are two circumstances which the trial court says. It says one, motive borrows from the confessional statement, that you had motive. Second is last seen. After that, my lords, is the conviction. Now, when I go up in appeal before the High Court, my lord, through the legal services, the High Court rightly says in paragraph 20 that motive is gone because motive flows from the confessional statements and inadmissible. Then we are only left, my lord, with the last seen theory. So last seen, my lord, by itself, my lords, if your lordship would have this judgment, which is, my lords, 2017-14 SCC page 359. And it deals, my lord, with your lordship's query posed to me also on 106.
This is happening in the night,
Night, certainly, my lord, night.
wee hours of 10th of April.
10th of April.
You are residing with your wife. You don't owe an explanation
Not,
how your wife died.
no, my lord, my explanation, my lord, with respect. That is why I'm pointing out 2017-14 SCC. Just kindly take the judgment, my lords, for a second. That explanation will come, my lords. Just take the judgment, my lords, for a minute. It's from legal services.
Dismissed. In the petitioner is reportedly in custody for more than 11 years. As and when the petitioner acquires the eligibility for premature release based on the remission policy of the state of Delhi. Superintendent of the correctional home where he is lodged shall move. Superintendent of the correctional home where he is presently lodged shall move the appropriate department in the government for securing his premature release in terms of such policy. If any such approach is made, we hope and trust that the application shall be disposed of in accordance with law as a case.
No, I'm grateful for this, my lord, order, but can I just point out, my lord, 3 lines from one judgment?
Nothing
Just
more,
paragraph 20.
Nothing more. Next matter.
Very well, my lords. Very well. Obliged, my lord. Your delay may be condoned, that is because of, yes.
Your lordship has recalled the judgment, my lord.
Acha.
Yes,
Is
my lord.
SLP 14837 still pending?
My lord, that is disposed. My lord, earlier your lordship cancelled the bail of one co-accused in Bhavan Singh.
So where is that disposal order? Let us see.
My lord, yes.
14837 of 2020.
My lord, if your lordship may have P14 of this SLP, I have annexed that order. P14 is an order of your lordship that no other accused person shall be released on bail. Thereafter, this order of P14 your lordships may have.
Same days.
Yes, my lord. My
Now,
lord,
this is just an interim order.
thereafter, my lord, this
Now,
bill
what
was-
is the final order on
the
this?
SLP allowed bail cancelled of
132, my lords, page 132,
132.
my lords.
Yes, my lord. Yes, my lord, the judgment, page P16, my lord. Lord, because both the impugned orders were, my lord, in fact, on the same argument. P16.
One four eight three seven is disposed of by this one.
Yes, ma'am. Bail was cancelled, my lord, and both the accused have same role. Same observations were there in the impugned orders. Therefore, my lord, this honorable court subsequently cancelled the bail of the other co-accused also.
So this accused stands on the same footing.
Yes, my
as-
lord. And in fact, my lord, the impugned order, if your lordship may have both the impugned orders in both the SLP, the observations are exactly same. Therefore, my lord, your lordship interfered subsequently also, my lord. And my
Have you
lord,
filed your counter?
my lord, he's for
Lord,
the
I am
state.
for state, my lords.
Who's for the?
Lord,
No, my
your
lord,
lordship has ordered to be released, my lord. Today, I don't think, my lord.
he is not appearing, my lords.
And my lord, may I point out all the accused persons reside in one house only, my lord. The FIR states. So, my lord, this argument that I was not served, my lord, merely sometime in office report it is written that the post office. But my lord, he was with great respect because earlier accused bail was cancelled, my lord, so he did not came forward.
One chance will be.
My lord, your lordship may fix a date, my lord.
You know? Respondent number 2 is not represented today. We have noted that in pursuance of the order dated October 6, 2025, passed by us while disposing of miscellaneous application number 1764 of 2025 in criminal appeal number 2486 of 2025, we have directed release of the respondent number 2 on interim bail, subject to terms and conditions to be imposed by the trial court. We are also directed that criminal appeal shall be released today for further hearing. Since the respondent number 2 is present today, we are not inclined to dispose of the appeal in this action. One last opportunity is one to the respondent number 2 to appear, contest the criminal appeal. The list criminal appeal 28 October is made clear even the respondent number 2 remains absent on the next day. May be constrained exposure to the criminal appeal is without any further limitation. Please give a copy of this order and the respondent number 2.
I'm so grateful.
May I please your lordships? I am appearing for the lady petitioners, my lords. We are under interim protection from your lordships. May I kindly bring your lordships' attention to two annexures, my lords. One is FIR number 878 of 2025, which is kept on record at page number 81. There are two FIRs registered against respondent number 2, who happens to be a money lender. Same story, same plot, my lords. Page number 81, my lords. And even the
Has she joined investigation?
Let's order, kindly have the order dated 7/7/25 months.
7,
7/25.
7/7/25.
To be arrested.
Vacation, partial court working days bench.
there are two.
Prisoner shall not be arrested.
Yes, there is.
Right.
Yes.
And then we have
Extended it.
continued.
Yes.
Yes, my lords.
So, very well, we'll fix a date, let them appear before the, you are for the
Great.
state.
And-
While issuing notice on the special petition. This court by an order dated 7th July 25. Sustained the this
Lordships.
such petition has been continued from time to time by this court. we are informed that in view of such petition granted by this court, the investigating officer did not call upon the petitioners to face interrogation. Having heard that counsel for the parties, make the petitioners to remain present at the relevant police station on 29th and 30th of February at 12. Release the special petition. Third.
Great,
Petition granted earlier shall continue in the ministry.
great.
Wait, please, my lords. 61 is fresh. The co-accused, your lordships have been pleased to issue notice, my lords, and protect him at the government servant as well in the same office.
I did.
Role is I.
Notice?
Yes, my lords. They are. Page 205, your lordships may have, my lords. Just give me- It's in the other one. It's 200. B20, my lords.
But thereafter we didn't issue notice.
No, this.
Not a notice issuing order.
No, this is not. This. No, I'm just pass it on. Sorry, my lords. 205 is not. Where is the order issued? I know that I'm just sorry, my lords. Yeah, my lords. It's 7-3 order. Sorry. There's some confusion. Since your lordships had asked me to file an affidavit, whether I was in service or not in that matter, I filed that affidavit.
What happened after this?
Then it's adjourned, my lords. It's pending. There was a letter circulated by the.
No, where is the notice issuing order on this?
I thought this was the order. That's how they came, my lords, on
No, have you checked up whether there is any order
7.
thereafter? After 7th March?
Yes, there is, my lords, that in view of the letter circulated by the council adjourned, interim protection shall continue, and there was respondent had entered appearance therein. Just give it to me. 24/9, my lords, it was.
There must have been an order in between.
I don't think there is an order in between, my lords. I appeared on the.
They appear respondents without notice?
I know that's the first time your lordships asked me to, because there was allegation that I couldn't be found. So the question that fell from your lordships was, where am I? So I informed my lords, your lordship, that I've been working in that office and I filed an affidavit. Then it came up, your lordships were pleased to.
This SLP is still pending?
Yes, my lords, it is.
Is a notice? Tag with SLP criminal 2660 public 2025. The next date of hearing, petitioner shall not be arrested in connection with the file with 6th October 2023.
It's a long number, my lords.
October 25 or 26?
25, my lords. I think it's 25 only, my lords.
October,
26, though the order mentions
October 26, but this order meant
25th.
is the number the same?
Yes, my lords, it is the same.
1020.
Yes.
FIR dated 26 October 2023. Hearing number 111-840-00-2231-020. Under sections, section.
And
Subject to joining investigators
Yes.
as and when called upon by the investigating officer.
I'm grateful.
My colleague is appearing through BC.
My lord, I'm the petitioner in serial number 62.
Yes.
Yes, my lord. There is a complete breakdown of the constitutional rights of Muslims under Article 14, 21, 25, and 19 of the Constitution, my lord, in Uttar Pradesh, Maharashtra, Uttarakhand, Assam, and etc. Now, there is this issue pertaining to I Love Muhammad. There is the banner of I Love Muhammad on 4th September was being put up in
Please come
Rawatpur.
to your prayers.
My lord,
Please come to your prayers.
Yes, my lord. The,
Is it a writ petition or a contempt petition?
my lord, it's a PIL, it's a writ petition, my lord.
It's a PIL.
Yes, my lord. And here
So
I'm,
in a PIL, your first prayer is issue directions for contempt of this court order.
yes, my lord, here there is,
Why should we entertain in a PIL a contempt prayer?
my lord, there is this
If there is a
judgment.
contempt, you can file.
My lord, there is a judgment of this,
First point.
my
Let
lord,
us just express our mind so that you can respond.
my lord, there is this one single point. There is a judgment of this Honorable Supreme Court in Ashwini Kumar Upadhyay, dated 28/4/23, my lord. Now here, there is,
Look into your own facts. Look into what the petition is all about. Right? Please have patience. Let us point out what is passing through our minds.
yes, my
And
lord.
then respond.
Yes, my lord.
Right? Because we have serious doubt about the maintainability of this PIL, which is based wholly on newspaper reports. And if you have seen the judgment of this court in Dr. B. Singh versus Union of India, 2004, volume 3, no PIL should be entertained based on newspapers unless you indicate the source of your knowledge in the petition. There is nothing in this petition. Let us see prayer 2. Let us keep aside prayer 1. Directing the respondents not to utilize the word Muslims and their revered prophets. Who are the respondents in the petition?
My lord, state of UP.
Who are the respondents in the petition?
My lord,
Does the state of Uttarakhand, does the state of Uttar Pradesh, does the state of Maharashtra,
Yes, my
does the state of Gujarat, who are the respondents, they utilize these words in any manner?
yes, my lord. In fact, the suspension of the constitutional rights are being executed only in the name of simple banner, that is I Love Muhammad. There is absolutely nothing wrong in that. But my lord, the entire constitution, there is a bulldozer that is happening. They are demolishing the houses. More than 200 houses are being
Please come
demolished.
to page 17, foot of the page. Please come to page 17.
Yes, my lord. Yes, my lord.
The state of UP is unable to uphold the constitutional rights of the minorities in its state. Therefore, the chief minister, we are not reading the next two lines, come to page 18 top, should be directed to step down. Is the chief minister of Uttar Pradesh a party to the writ petition?
My lord, the chief secretary has been made a party.
So we will pass an order against a person who is not even a party.
My lord, I'll make requisite amendments. My lord, but this is a serious petition, my lord.
Dismissed.
My lord, there are serious violation of human rights are happening, my lord, in UP
Next
and
matter.
Maharashtra, my lord.
Please, my lord. My lords, may kindly see the High Court while granting extension.
Issue notice returnable on 29th October. The period of parole granted to the petitioner shall stand extended till the next vote of them.
I'm so grateful, my lord. My lord, may kindly permit me to serve the standing counsel for the state of
Standing
Gujarat.
counsel.
I'm grateful, my lords.
Please.
My lord, my grievance before High Court was, my lord, that recovery officer had passed an order for demarcation of undivided property. So, my lord, I am neither a borrower nor a guarantor, my lord. I am a co-owner of an undivided property, my lord. And before the High DRT for last 10 years, my lord, I approached High Court saying that I am willing, in terms of Section 44 of TPA and Section 4 of Partition Act, my lord, I am willing to pay the amount of the bid. But kindly appreciate in October 24, because I didn't want to, my children to inherit this litigation, but I approached bank saying that please settle it, whatever is there, because I had not taken the loan.
Where is your OTS? For one-time settlement, have you approached the bank?
Yes, my lord, I had
Where is your,
page,
where
kindly,
is your proposal?
yes, my lord, kindly turn to page, page 95, my lord, page 95. My lord, there were 3 banks involved. I wrote to them, all of them, that I am willing to settle, please tell me. They did not respond to me, my lord. Rather,
Where is your offer?
you may not, I just kindly turn to.
You are filing a petition before the bank. Where is your offer?
But because I was not aware what is their claim. My lord, I am neither borrower nor guarantor. I am not nobody. My lord, I am only trying to save my ancestral property from a stranger entering into my property. My lord.
You have 2 tiers under the RDB Act. You have a first appeal before the DRT, a second appeal before the DRAT. High Court has declined interference only on the ground of availability of alternative remedy.
But my case was that the recovery of Sir Milord does not have jurisdiction to pass a demarcation order in respect of a preliminary decree passed by.
It is an order which might be erroneous, but is passed in the exercise of jurisdiction.
But
It is to be distinguished from an order which is passed absolutely without jurisdiction.
only
A
one.
wrong order does not make it always an order without.
But kindly just turn to page 56 for a minute. Not kindly just turn to.
There are decisions of our court that we should not.
But arbitrariness is there.
But
We are restrain the High Court from interfering.
But kindly
in these
appreciate.
matters.
No, but
And
kindly.
we will be entertaining.
But kindly see one thing.
High Court follows our decisions.
But kindly see only one thing, Lord. It is a totally arbitrary auction exercise, Lord. Kindly see. Just kindly turn.
Have your statutory remedies? Go and pursue.
Lord, I'll pay the money, Lord. Kindly just turn to page 56 for a second.
We are not
Lord,
trying
only,
to interfere.
only page 56 for a second, Lord.
Sorry. Go before the bank and make a suitable prayer.
Lord, I had made that prayer.
Yes.
Only one thing, Lord. I'll unnecessary, Lord, be dragged into it. I'll make the entire payment what the auctioneer is making, Lord. Lord, only give me protection for 10 days, Lord. I'll approach the appropriate court.
You
Lord.
can't.
But only for 10 days, kindly.
Cannot be done, sir.
Lord, kindly see, I'm a
We would be going against the Constitution Bench decision of 1952.
Lord, I appreciate. But I am
If
not.
you appreciate that,
But I'm.
we can't pass an order while we are not entertaining your petition. Giving you protection for 10 days means we are granting an interim order in a matter where the final relief is not granted.
But only.
Please take up AIR
Your
to page 12.
Lord,
Whether we can do it.
Your Lordship has power. But it will.
Supreme Court Constitution Bench has said that no court has that power. How can we, sitting in a combination of 2, go against the Constitution Bench of 5?
Lordship will only protect me for 10 days. I'll take appropriate steps, my Lord, because it will unnecessarily
Yes.
add more litigation, my Lord.
Next matter.
My lords, the reference court has awarded rupees 77, which is more than what the award was passed initially. My lords, they have taken reference of some other village where rupees 88 was initially awarded. But my lords, the problem is that no documentary evidence was produced by the claimants, no sale exemplar was produced by the claimants, and the evidence of the special land acquisition
Where is the
officer.
certified copy of the order? Under the Supreme Court rules. Madam Priyanka, you are there? What is this happening? Come to page 126, 127. Your statement is kindly exempt us from filing the certified copy of the order.
This was
126, 127. So the clock of limitation is still running. You have not even applied for the certified copy of the order. Next. Come to page 129. This is the flow chart.
Please, my lords.
When is the order passed by the High Court? 20th of July 2023.
Please, my lords.
And serial number 2 is 18th of December 2023. The first action after the judgment.
Please, my lords.
Your limitation period expires on 19th October 23.
Please, my lords.
There is no explanation what you were doing during the period of limitation. And in view of the recent judgment in Shivamma, this is reported in 2025 SCC Online 1969, judgment by Justice Padiwala. You should not include. You have not explained anything. Dismissed as time barred.
Beautiful, my lord.
May it please, your lordships. The facts are a little bit complicated, your lordships. In fact, though the facts would not be relevant, but I'll have to mention that let's say two courts concurrently, the trial court and let's say the first appellate court.
Will be maintainable against a review rejection order.
My lordships, in fact, my review is never heard on merits. There's one judgment of your lordship.
Review has been rejected.
Please, your lordships. In fact,
Yes or no?
yes, your lordships.
What does Order 47, Rule 7 say?
My lordships, there can't be a review on a review.
There cannot be an appeal against a review rejection.
Please, your lordships.
There can be an appeal against review allowed.
Please, your lordships.
Right. So your SLP against the parent order has been dismissed on 13th of March 2015.
Please, your lordships.
Filed a review. Your review has been dismissed. Now please read out Order 47, Rule 47.
Please, your lordships. Now, before that, in fact, my review.
Question of before that.
My lordship says I'm reading 47, order 47, rule 7, your lordships. The order of rejection not appealable. Objections to an order granting
So,
order granting
it's not appealable.
Please, Lord. I'm not an appeal. In fact,
This is not an appeal.
my lordship, sir, now the High Court completely misconstrued as to okay, what my case was, your lordship.
We don't expect these SLPs from you.
My lordship, but the difficulty as of now is my review was dismissed on 2 grounds, your lordships.
Dismissed.
Please.
So SLP is not maintainable. Can't hear.
Item 18, my lord, there's a delay of 212 days. And even on merits, frankly, my lord,
Yes,
I'm praying that my lord may dismiss it on the ground of delay.
very good. Dismissed as time barred. Let me tell you, Mr. Additional Solicitor,
Please,
we
my
will
lord.
about to issue notice.
My lord, I take back my words, my lord.
No.
My lord,
No. Once it has come from the solicitor, then it may be dismissed as time barred. That will be the order.
No, my lord, why I said that was because the delay has not been
No.
explained properly. My lord, may issue notice, please.
Sometimes, Mr. Solicitor, we look into the merits also. The judgment of the Delhi High Court is absolutely in the teeth of K. Janki Raman.
Please, my lord.
But now that this is just notional promotion, without any arrears, let it be dismissed.
It please your lordship. Because in this, the time period granted in the agreement to sell was 2 months, my lords, and there were repeated threats. My lords, they came to my house.
They went to your house
They
with
came
4
to our
lakhs.
house.
They have shown from their bank account that they had withdrawn this 4 lakh.
Milos, and Milos, the money that was to be paid, Milos, has to be paid from banking channels. The withdrawal of cash, Milos, with great respect, were in a sale deed, in an agreement to sell, Milos, they had the option, even with the legal.
Complaint findings.
Milos, only one submission, Milos, 4 lakhs, Milos, 2015. Milos, kindly Lordship may consider that at least the 4 lakhs will be plus interest, because Milos, the High Court and the courts below have omitted to grant me interest, Milos. Only that request, Milos, because it will be highly inequitous to Milos allow this 680 square feet.
We are just.
Milos, my lord, Milos, I will pray, Milos, only that 4 lakhs may be granted with interest, Milos, only that additional, Milos. I am foregoing any other submission, Milos. May I request for that? With great respect.
Clarify that. Of course, this then again, they will come and say we were not. The money.
Milos, we accepted, we were, Milos, on the last day they come.
Simple dismissal.
Milos, only on the last, Milos, may I answer that query, Milos? Your Lordship had made an observation. It's my duty to respond, Milos. They came on 29th, the last day was 30th. They issue a legal notice without a check. Milos, the legal notice is without a check. Milos, they had the opportunity to give the check with the legal notice.
Yes,
And Milos,
next matter.
I'm only saying, Milos, this 680
Yeah, we
square
are-
yard property will be going for a song, Milos.
You should have realized it then.
It's only I'm a very poor person. My property will go 680 square feet. 680 square feet.
Who appears in the next matter, item 50?
I am seeking a passover. We are being led by learned senior counsel, Mr. Niranjan Reddy.
My lords will recollect, they came and they said last minute they wanted an adjournment. Today it's.
Because there was a family
My lords, I'll
emergency
point
last
out
week. We
what's
are just seeking a
happening.
passover.
Would my lords
Mr.
take
Niranjan
the
Reddy is
second
in
matter
foot
for a
13 on
minute?
his legs.
There is something like 280 days delay, and my lords may see page 239 of the second matter.
Madam Arora, let it be in the presence of the other side.
My lords, then pass it over. Let there not be an adjournment at least. We'll come back on the next round.
Pastor.
Please, Your Lordships. In item 51, we need 3 weeks' time to file the affidavit, Your Lordships. The council is in some personal difficulty. However, we are handing over the DD insofar as the maintenance amount is concerned.
My lord, for month of September.
Time to file the affidavit in terms of the earlier order dated 15 September 2025 is extended for a period of 3 weeks as last chance.
Deeply grateful, Your Lordships. We are handing over the copy of the DD.
Released after 4 weeks.
My lord,
Handing over the
returnable
copy of the
date.
DD. also.
Check amount of,
30,000, Your Lordships.
just make a photocopy.
We have a copy, Your Lordships.
You have a copy.
Yes, Your Lordship.
It is recorded that check for an amount of rupees 30,000 has been handed over the court due to the council.
The reason behind this is, Your Lordships, the DD was prepared. However, the maternal grandfather and the other relatives of the respondents have shown certain
My lord-
interest in this amount. That is why we are handing it over in the court, Your Lordship.
My lord, may I have a returnable date, my lords, please?
Returnable date that is enough. Please, after 4 weeks, enough. Just find out the returnable date.
Grateful, my lords.
Deeply grateful.
Grateful.
Wait, please. I have filed rejoinder, Millard. This is regarding maintenance of a government doctor's child, Millard. Millard, the father is, Millard, earning 3 lakhs, Millard, through private practice, Millard. And
You are
officially,
also earning 84.
yes, Millard.
You are also in government employment.
Also government employee, Millard, but the child is studying in, Millard, in private reputed schools, Millard. And the High Court,
We will not interfere with this reduction of 10 to 5.
Your lordship, I'm appearing on behalf of the respondent in this matter.
Yes.
At the very outset, I submit that the present SLP arises from a very well balanced and
That's a
reasoned
very well,
judgment.
madam. We will hear you after the petitioner concludes.
Oh, yes, your lordship, I'll wait.
but kindly see page number 4, Millard, paragraph 6 of the order of the Honorable
here.
High Court.
The order, what has the order done?
On wrong fact, Millard. Fact is
What has the order done? What has the impugned
reduced
order
the
done?
amount,
Let
Millard.
this is
on
From
incorrect fact, Millard.
10 to 5, 10
22.
to 5 for the petitioner number 1.
No, Millard. Both petitioner number 2, only for child only.
For the child, it is reduced from 20 to 10.
30 to 15. 30,000 to 15,000. Only for child. She is not claiming maintenance, Millard.
Ultimately, the figure comes to the same, but we have recorded for petitioner number 1, it was 10,000, which has been reduced to 5.
Millard, kindly, the age of the child at the time of reduction, Millard, 11 years. But High Court recorded 8 years. Lordship, kindly consider that fact.
Sometimes we feel that we have misread the brief. Right? What I said at the beginning, petitioner number 1, white, from 10,000, it was brought down to 5. And for the child, it was brought down from 20,000 to 10. You said no, 30,000 in all. Please come to paragraph 8 of the impugned order. Of the High Court. Please come to page,
Yes, Millard. 4.
internal page 2, which is page 4 of the SLP at the bottom.
Yes, Millard.
Accordingly, maintenance amount of 20,000 per month, which was directed to be paid by the revision petitioner, to respondent number 2, that is the wife, is reduced to 10,000 per month. Likewise, maintenance amount of 10,000 to be paid to the respondent number 2 is reduced to 5,000 per month. This is for the child. And, first one is for the child, second one is for you.
Respondent number 2.
We propose to keep it at 20,000 for the child. Right? So far as you are concerned, it has been 10,000 has been reduced to 5,000. Be happy with 5,000. So out of 35,000, we propose to keep it at 25,000. What do you say?
Respondent number 2 is daughter, my lord, age 7 years.
We are interfering with that part of the High Court's order,
Yes.
which reduces for the child
25,000, okay.
25,000 in all. Yes, madam, what do you say?
Your Lordship, I'd like to submit that Your Lordships on 17th of February 2025 had issued notice only on the aspect that the respondent's income has been underrepresented and we have concealed it. In our counter affidavit, we have filed the salary slips supporting that we have not concealed any of the income, and the income difference between the petitioner and respondent is not a lot. The respondent also has to maintain his parents. We've attached the documents to support that there are a lot of medical expenses occurring which he needs to take care of.
Are you not working in global multi-specialty dental care?
No, Your Lordship, the screenshot that has been attached by the petitioner, the Practo screenshot, is not real. It is a fake document, and we've also mailed it to Practo to correct it and take it down. All the documents that have been attached by the petitioner.
What is your net salary?
Your Lordship, my net salary is around 69,000 per month. Approximately.
You're a government doctor.
Yes, Your Lordship.
You're getting 69,000.
After deductions, because my in my salary slip, the maintenance.
Where is your salary slip?
Your Lordship, my salary slip is at annexure to. Just a second.
Page number 31, their
It's
counter.
page number 31,
126.
annexure 3, Your Lordships. My apologies.
1,26,000.
After deduction, it comes down to 69,000 because the maintenance has been attached. I am also paying for a loan. That is why the salary gets deducted to 69,000, Your Lordship.
You look after your old parents?
Yes, Your Lordship.
Please continue to do that. You also look after your young child. Pay 25,000 for the child. If granted. The
Grateful,
appeal is
Your
directed against the order dated 21st November 2023 passed by the High Court for the state of Telangana at Hyderabad in criminal division number 609 of 2021. Maintenance that was awarded to the appellant being the respondent number 2 for the High Court was reduced from 30,000 to 20,000, both for herself as well as the daughter of the families. We are of the considered view upon hearing land counsel appearing for the respective parties. A sum of rupees 25,000 per month for the child of the partners would be sufficient. Ordered accordingly. However, we verify that since the appellant is a doctor in the employment of the partner, the entire amount of 25,000 shall be spent for the well-being of the child of the parties. Yes.
Let them clear areas.
Paid. The amount of 25,000, both current and arrears, be cleared by the respondent number 1 within a period of 8 weeks from which.
Publish.
Grateful.
Deeply obliged.
Well, it's item 53, Millards.
Lord,
State
item 53,
State has
counter.
only filed the counter on Saturday, Millards. I believe it's not even come on record, Millards. But give me some time to file my.
Counter affidavit has been filed by the respondent state of Bihar on Saturday. Stop para. Office is directed to place the counter affidavit on record. Stop para. Rejoinder affidavit be filed within 27. List on 3rd.
Well, it's in 54. This is a legal services matter. Notice was issued.
My lords,
He's already spent 14.5 years
I'm
inside.
taking some time to file my counter.
They
Just 2
filed
weeks,
their
my lords.
they filed their wakalatnama in July, my lords.
My lords, we are waiting for some instructions to come. We need to file certain statements.
But he's spent 14 years, 5 months, my lords, already, all 3 of them. Just, my lords, have page 106.
If you want us to examine the merits, then it will remain pending. Otherwise, we may condone the delay, dismiss it, and direct that in terms of the remission policy, their cases pending.
Which I want to get, my lords, because without a notice.
Choice is yours.
Well, because without a notice, I mean, just see when the order issue, when notice is issued, my lords, it's specifically noted.
Very well, very well. We give the choice to you.
Well, this is a legal service matter. I cannot, my lords, with that.
My lords, it's 2 weeks. Yes. Grateful.
Counter by 3rd November, rejoinder by 10.
Because I don't want to file a rejoinder because then it will be again some.
Release on 11th.
Just a small criminal, they will take instructions how much actually they have underwent because this is legal services. I'm not.
File the custody certificate also.
I filed that too very.
Updated custody certificate.
Counter affidavit, the state shall indicate the period of incarceration suffered by each of the petitioners.
Deeply.
These matters have to be heard on some NMD. Might take some time.
What matters are these?
These are all regularization of data entry operators in the state, about 600, say 40, it's on 40 matters batch.
I succeeded both before the learned single judge as well as the division bench.
How long do you post to do?
To 45 minutes. Sir.
Another 45 minutes. 45 minutes.
Slot hai. देखो चलेगा 12 November 2. 12 November.
Please, very good.
Deeply grateful.
Obviously.
Since that matter regarding our respectful submission is covered by your lordship judgments, which your lordships have rendered in the TET matter on the 1st of September. But my judgment
let it await the decision on the review petitions. We are
In fact, otherwise
There's
also
some-
covered, my lord, we want to make our submission. Review petition
there are some review petitions which have been filed, we are told,
by the states.
by some of the
States have filed it.
aggrieved teachers. Aggrieved teachers, because we had given them 2 years' time to qualify in the case.
Yes. Here, my lord, we have given 5 years, my lord, in our scheme. More than what your lordships are giving.
No, but
Our scheme.
you may have given 5 years, that 5 years have concluded.
No, but we have, that scheme had come in 2022 to not give effect to the judgment rendered in 2021 in the first round of this case. Then we not we framed this scheme. Everything else was accepted. Only this clause category 3A people who had not passed. So we said we'll provide you training to give the test. We will give you 5 years, and otherwise everything else will remain the same. So that 5 years is going to expire in 2027. So there's 2 years more, my lord, even as part of
No, we have given time, the judgment was delivered on 1st September, so 31st August of 27.
So
We have time.
here 5 5 years will expire in 27.
Well, we have some submission. I beg to intervene. Well, we have some submissions as far as the 2010 notification is concerned. Your Lordship will consider that. But I do believe that some people haven't been served the notice yet. Well, if your Lordship.
Yes, the office report shows that, everybody has not been served. That is true, And also, I understand that they have filed some counter which we have not received. Some counter affidavits have been filed. So, we could file our rejoinder. But we are saying, that this judgment, the second part, first part is the reference, regarding minority institution. The second part, we are not concerned with the first part. We are concerned with the second part, and second part covers our case, in our respectful submission. My friend.
Only point, my lord, I would beg to make before your Lordships, my lord, that your Lordships, my lord, had noticed, my lord, in that case, my lord, the provisions of the NCTE Act. And, my lord, thereafter, my lord, there is no finding with respect to Section 12, capital A of the NCTE Act. If your Lordships, my lord, can you see, my lord, that judgment of your Lordships? And incidentally, my lord, in that judgment, my lord, three previous judgments of your Lordships were noticed. My lord, the very purpose of amending Section 12A, my lord, we have referred to in our counter, my lord, that we have filed, that only with the view to, my lord, override the judgment of this court in Upendra Rai, my lord, the Parliament had amended Section 12A, so to say, my lord, inserted Section 12A, just to obviate, my lord, that the NCT does not, which the NCT did not have the competence, my lord, to make legislations with respect to schools, have now been incorporated by virtue of this. And, my lord, it has been effected from 1/6/2012.
NCT is the examining body, so therefore it was necessary to confer power on the NCT under the NCTE Act. But today,
that power has been.
Our judgment was on interpretation of Section 23.
Exactly.
Of the RTE Act.
Exactly, my lord. So, I would beg to submit, my lord, the interplay of.
By the second proviso to 23, which was incorporated later.
My lord. My lord.
Please.
My lord, what I would beg to pray before your Lordships, my lord, if your Lordships can you put up the matter on a non-miscellaneous day, onto a farm date, my lord.
We'll keep it on.
All that we are respectfully submitting is, we'll make the service. We'll file our rejoinder, we'll endeavor to make all the service, which is on. And they are given an undertaking, they will not press for the contempt.
Yes. My lord, your Lordships, my lord, can you record my words, my lord? The content was moved, and my lord, I made a submission before the court.
Yeah, 90. You are not granted leave, no?
No.
Huh? Wednesday. Leave keeping hoga. If you direct it will come. 19th at 2 o'clock.
19th November, my lord?
Yes. In the meanwhile, state of Tripura shall take steps for effecting service on the respondents who are yet to be served.
And we are also permission to file
a rejoinder within 2 weeks.
Check counter for those who have not filed so far.
My lord, the first matter, my lord, I have filed my counter, my lord.
If not filed, may be filed by 2 weeks. Rejoinder affidavit to the counter affidavits which have already been filed and which may be filed in terms of the liberty granted above, may be filed by the petitioners by 14th November.
Deeply obliged, my lord.
I'm so grateful. I'm so grateful.
There is one IA which we had to file, because there was some delay in filing the spare copies in the registry because of the large number of respondents. That IA 175,483, that delay 175,483, that may be condoned.
Condoned allowed.
Very
allowed condoned.
Obliged, my lord.
So great.
My lord, the notice is served on the respondents. The state is yet to enter appearance. My lordship was pleased to issue notice. The last occasion,
Nobody has entered appearance on behalf of Tamil Nadu.
not yet, my lord. I'll inform the standing council again.
None has entered appearance on behalf of the state of Tamil Nadu, despite service being effected. It is the special petition. First December.
Well, the interim order may be extended.
In the state of hearing, service will be effected to the standing council.
Obliged.
Marod, in item 58, I am led by Leonard SG Marod. He is stuck, Marod. So request is Marod may fix it any other date, Marod.
Can I make a suggestion to your lordships? My lords, I have replied to the show cause notice. Last time they said that they haven't received it. My lordship, we direct the adjudicate the show cause notice, my lords, rather than deciding this question of suspension. 2.5 months I've already suffered. So in 2 weeks, if they decide it, and I can participate subject to outcome of the show cause, my lords. By 31st October, when they may decide it.
For adjournment, a request for adjournment of hearing on behalf of Mr. Mehta and Solicitor General. Stand over till 31st October. In the meanwhile, what is the name of
Bhilai Steel Plant. Bokaro, sorry, Bokaro. No?
Bokaro or Bhilai?
Bhilai, BSP.
Bhilai.
Bhilai.
Bhilai Steel Plant. Just take it out. Mr. Gaurav Agarwal and Senior Counsel for the petitioner submits that a reply dated
24/9/2025.
4/9/2025 has been submitted in response to the show cause notice dated
11/9/2025.
11/9/2025. The competent authority of Bhilai Steel Plant may decide the show cause give its decision in the proceedings arising out of the show cause notice by the returnable date.
After hearing us, my lords.
Upon granting an opportunity of hearing to the commission.
My lords, grateful.
Resultant decision shall be placed before this court by the returnable.
Only one request I had is subject to your lordship's approval. If the tender something comes up, I may permitted to participate subject to outcome of that, my lords. If they uphold the show cause, I will be out, my lords. For 2 weeks, if that can be considered by my learned colleagues.
Marod, just one humble request.
Yeah, 30th, for 31st, my lords.
No,
Whatever we did.
Marod, just one humble request. It's a practical issue, Marod. Now, Diwali vacations are there. Now, since we have to hear them and pass a detailed order after examining each and every allegation, which they have also mentioned in their reply, that certain only sample was taken or something like that.
Vacation of 5 days like us.
Marod?
Steel plant has a vacation for 5 days like us.
Marod, what I am submitting, Marod, that
No, tell us. It is only on Diwali day that the plant will be closed.
very well. That's not an issue, Marod. But I am requesting
No,
some more time to be given because a detailed order needs to be passed, Marod, after hearing them. So
Today we are on 13th. We give you time till 31st. Almost.
And the allegation is, Marod, that the forged documents which have been.
Look here.
So I'm just.
You have formulated a novel procedure to bypass Eurasian equity. Right? Knowing your conduct, we will not grant you further.
Very well. I bow down. I was just making
Get
this
the order by
assumption.
Grateful to you.
Yes, text.
Obliged, your lordship. Very great.
Please, my lords, I beg to appear for petition on the matter. Thrice the time has been given to the state to file the additional counter.
We filed it just this morning. It might not be on
This
record.
morning. This is the additional counter.
Yes, ma'am.
Additional counter has been filed this morning by the state of English. This is limited to place the same on record. Released on first Monday after two.
Grateful. Lords, my sincere apologies. The learned senior counsel
Well, it's my-
on his legs before court 13.
Let's just point out, because
It's happening
My
too
lords,
often.
my lords may keep it for Friday or any
It's
other.
happening
day,
too
my lords.
often, my lords. Actually, that's the difficulty.
Which one is now?
313 item
50.1, there's a whole chain.
Oh, P50.
Well, it's in 50, the lordships have dismissed on the ground of delay several petitions, both merits and on delay. Can I just hand
My
over?
lords may keep it for any other day, my lords. Mr.
Identical FIR.
Dr. Muralidhar, we are a member of the bar. Take an order.
Only the second, because it's the second time.
Just realize what will happen. It's like missing a penalty. You could not get an adjournment from the court.
Can I just request something?
First Monday after the.
On 50.1, can I request something, Lord? I'm not pressing, my Lord may not pass an order, but just two very important facts, my Lord. I'm not pressing.
Not on.
No, don't worry.
First Monday after Diwali.
My Lord, can my Lord at least record that no further adjournment may be given, my Lord? 5 times
Please
they've
make
sought
clear that no further prayer for adjournment.
by the petitioner.
No further prayer for Passover or adjournment shall be entered.
By the petitioner.
So first call it will be called.
Mention item 53.
April.
50?
53 Malats. Malats have granted me time to file my rejoinder. Malats may extend the benefit from exemption from surrender. Malats. Wait for Malats. Malats had not said so
You
earlier.
have not said so.
I believe not in this.
53 may interim protection granted.
My lord, the trial court record may be summoned, my lord. It is against the conviction from 3 courts, my lord.
We will consider. You have filed your counter.
We have filed the counter.
Item 60 for exemption to surrender to continue.
हाँ
Grateful.
देख लेना जहाँ जहाँ interim order है all matters में